Okay, I think we can get started. I think hopefully people have joined. So, first off, I just want to thank you all for joining us today, and welcome you to our Prevailing Wage 101 webinar. My name is Jill Gigstad, and I am the Communications Specialist with the Indiana, Illinois, Iowa Foundation for Fair Contracting. For those of you who don't know us, the IIIFFC is a labor management organization that was created to raise standards in the construction industry. One of our main goals at the IIIFFC is to ensure taxpayer dollars are spent wisely on projects completed by responsible contractors and skilled workers. We help public bodies and contractors understand laws and policies that impact the public construction industry, and that's why we host various seminars and webinars on a variety of topics. Topics such as OSHA compliance, FOIAs, public bidding, responsible bidder ordinances, and of course, prevailing wage. We would say prevailing wage is one of our bread and butter issues, and that's why we're thrilled today to have two amazing speakers who I would call experts on the topic, who are going to go in more depth on the Illinois Prevailing Wage Act and the economic impact of the law. We're going to have Melissa Binetti go first. She is counsel with the IIIFFC. And then we'll have Frank Manzo IV, who's economist with the Illinois Economic Policy Institute. He's going to go second. And then we'll do a Q&A after both presentations. So please add any questions you have to the Q&A box or the comments box, and then we'll go over those at the end and go through them. One other kind of housekeeping thing, we are recording this webinar, so we'll send a link of the recording to you along with the two presentations. And if you want to revisit kind of what we've discussed later on today, or at any time, we'll have those links to you. And then if you are an attorney and you're present today, we will be sending you a CLE credit for this. So look out for an email from us later today about that. But I think we can get started. So I would like to introduce our first speaker, Melissa Binetti. She obtained her law degree and a certificate in labor and employment law from Chicago-Kent College of Law. Prior to joining the IIIFFC in 2007, she represented Taft-Hartley Benefits Fund and worked in-house with the Illinois Education Association. Besides delving into prevailing wage and Davis-Bacon matters, Melissa enjoys reading, biking, and watching her kids play sports, and is working on her pickleball skills.
Thanks, Jill. I also want to thank all of my colleagues at the IIIFFC who make this such a fun and interesting job. In particular, Cara Principe and Michael McNally in our office, two attorneys who were very helpful in having discussions as I prepared this presentation. I do have a couple disclaimers. First, this is very much an Illinois Prevailing Wage Act 101. It's an overview of the act. If you are looking for a deeper dive into prevailing wage matters, the IIIFFC is going to be putting together a conference, a public construction conference in 2025. So please stay tuned for more information on that. The other disclaimer is that I am not an employee of the Illinois Department of Labor. And so any opinions I might be sharing today are my opinions based on our experience here at the FFC, but of course it is the department that has ultimate authority on determining compliance and enforcement issues. So with that, we'll talk about why are we discussing prevailing wage today. First, we think it's important for public bodies to be familiar with the act in case any issues come up on their projects. In addition, they can be held liable for violations in certain circumstances. We want workers to know their rights under the act, and we think it's important, of course, for contractors to know the expectation and responsibilities under the act and making sure that they're in compliance. When we talk about prevailing wage laws, we're often talking about federal prevailing wage under the Davis-Bacon related acts, or state prevailing wage laws such as the Illinois Prevailing Wage Act, which we're focusing on today. Section 1 of the act outlines the broad policy, and it's really different provisions of this section that we're going to be focusing on and breaking down today. So it's the policy of the state that a wage of no less than the general prevailing hourly rate as paid for work of a similar character in the locality in which the work is performed. And when we talk about locality, in Illinois, where locality is based on county, shall be paid to all laborers, workers, and mechanics employed by or on behalf of public bodies engaged in public works. And we're going to be talking quite a bit about what's a public body and what are public works under the state prevailing wage law. Prevailing wages are predetermined wages for workers engaged in the construction of public works. And we have quite a bit of case law in Illinois that supports this purpose and broad coverage under the act, starting in the 80s, to ensure people working on public works receive a decent wage, and then also recognizing that this protects local workers and removes incentives to import less expensive labor from outside the locality. When we talk about public bodies, we have what we typically think of a public body, right? The state, such as the Illinois Department of Transportation or Capital Development Board. And then we also have our counties, cities, library districts, school districts, our traditional public bodies, and other political subdivisions. But the Prevailing Wage Act also covers institutions supported in whole or in part by public funds. So some non-traditional public bodies, which can be entities that receive public funding, such as tax money or grants, and engage in construction. They are also required to comply with prevailing wage requirements, even if the project itself at times is not directly financed by public monies. So we saw in the Illini Community Hospital case that a not-for-profit hospital was a public body because it was supported in part by public funds, in particular, it received tax money. This is a fact-specific inquiry. There's no bright line rule, 30% funded, 70% funded. It is something that would be determined on a case-by-case basis when we're considering these non-traditional public bodies. So we also have case law that gives us some guidance on what a public body is. In Opportunity Center of Southeastern Illinois, a not-for-profit was a public body for purposes of the Prevailing Wage Act because it received over half its revenue from contracts with the Department of Health and Developmental Disabilities, and was also had some public support through tax money. In the McKinley Foundation case, a private foundation was covered under the prevailing wage, where construction of a specific project was financed with bonds issued by the Illinois Finance Authority Act. The court noted that this Act specifically applies to non-traditional public bodies, and by opting to receive this financing through the IFA, that particular project was covered under the Act. However, there are a few limitations. In Town of Normal v. Hafner, the court recognized the Prevailing Wage Act does not apply to a private developer where the developer receives TIF incentives. Despite multiple amendments to the Act, the public works definition has not been amended to include tax increment financing, and so projects with those incentives are not covered under the Prevailing Wage Act. So kind of summarizing the types of projects that are covered, we have those that are with a direct contract between the public body and a contractor, where a non-governmental organization is funded in whole or in part by public funds or financing, where financing for the project comes from a specified funding mechanism on the statute, for example, the Illinois Finance Authority Act that I mentioned, or projects are financed in whole or in part with bonds, grants, loans, or other funds made available through the state or any of its political subdivisions. And we'll see this with some examples of renewable energy projects in a minute. Section 2 defines public works as fixed works constructed or demolished by any public body or paid for wholly or in part out of public funds. So we see in Section 2, there's specific references to the Illinois electric vehicle charging station projects financed pursuant to the Electric Vehicle Act, as well as renewable energy projects that are required to pay prevailing wage pursuant to the Illinois Power Agency Act, or IPA. These types of projects were added to the Prevailing Wage Act as part of the Climate and Equitable Jobs Act, or CEJA, which was passed in 2021. CEJA is the state's plan to completely decarbonize its energy sector by 2050 in an equitable manner that invests in the state's workforce. These are both statements that are straight from CEJA. The goal is to maximize benefits to Illinois residents, both with equitable access for residents, as well as this investment in the state's workforce with certain prevailing wage requirements. So some of the projects that have prevailing wage requirements are utility scale wind projects, utility scale solar projects, and other solar projects such as projects on public school lands. More recently, the Illinois Power Agency Act was also amended to have prevailing wage requirements for new, modernized, or retooled hydropower facilities. This isn't an exhaustive list, but gives some examples of these renewable energy projects that are covered. There are some exclusions, particularly related to solar projects, when we have owner-occupied residences, single and multifamily, but again, owner-occupied, as well as houses of worship, where there's an aggregate capacity of less than 100 kilowatts in the size of the project. In the definition of public works, work performed directly by public utilities is not covered. However, a construction project may be covered if it's performed by a third party, contracted by a public utility, and performed in public rights of ways. This is, again, language from Section 2 of the Act. Public utility is defined in accordance with the Public Utilities Act. And typically we think of those companies engaged in the production of heat, electricity, water, sewage disposal, and oil or gas conveyance by pipeline. However, Section 2.1 of the Prevailing Wage Act also expands that definition of public utility to include some communication services if the projects exceed 15 aggregate miles of new fiber optic cable. Some of these communication services that are listed in the Prevailing Wage Act include telecommunication carriers, providers of cable and video services, as well as providers of broadband services. And that's not an exhaustive list, just some examples that are in Section 2.1 of the Prevailing Wage Act. The public works definition includes some very specific types of projects, and these are some of the recent amendments to the Prevailing Wage Act, including the removal, hauling, and transportation of biosolids, lime sludge, lime residue from a water treatment plant or facility, as well as certain power washing projects. For someone like me that recognizes broad coverage under the Prevailing Wage Act, these seem to be pretty straightforward, that they would be public works projects. But I know from experience, particularly in the lime sludge case, the FFC was aware of some public bodies that had these contracts and didn't think that they were covered under the Prevailing Wage Act. We reached out to the public body, discussed it. Again, at least one public body had the position that these were excluded under a narrow agricultural exemption. So we reached out to the Department of Labor, asked for their opinion. The department's position was that the description of the project sounded a lot like maintenance, which is covered in most cases under the Prevailing Wage Act. There's just a few exclusions for maintenance. For example, when it comes to landscape work and things like lawn mowing. But the Department of Labor agreed that these seemed to be public works projects, or these would be public works projects. There was still some pushback from the public bodies, and so this amendment was brought forth, and ultimately the act was amended to exclude this work explicitly. I'm guessing, though I don't know firsthand, that there was a similar sort of discussion that happened with the power washing projects as well, to make sure that they are also covered under the act. Another amendment from 2023 is public works includes projects that involve fixtures or permanent attachments affixed to light poles, as well as certain public-private agreements. Most recently, this reference to the Department of Natural Resources World Shooting and Recreational Complex Act includes prevailing wage requirements as well. Next, we look at what types of workers are covered under the Act. These are workers that are employed by contractors and subcontractors engaged in the site or the construction, as well as workers engaged in transportation of material to and from the site. However, the Act excludes transportation by sellers and suppliers of materials and equipment. And this is discussed in the Sparks and Weevil case from 1993. This is a provision that causes some confusion in the state because state prevailing wage requirements are different than federal Davis-Bacon. Again, transportation by a contractor's employee, where the contractor is, for example, sending a truck driver to go pick up materials or equipment and bring those materials or equipment back to the job site, is covered work. The exclusion applies to the seller or supplier. For example, a quarry that is supplying rock or other materials to a project. If the quarry's employee delivers those materials, that transportation would not be covered by the supplier of the materials. But when it's the contractor's employee doing the transportation, the work is covered. I mentioned earlier, the Act does explicitly cover maintenance, stating in Section 3, the wage for a tradesman performing maintenance is equivalent to that of a tradesman engaged in construction or demolition. This also covers maintenance work performed on equipment. The Department of Labor has some specific responsibilities under the Act, which we're going to discuss in more detail. However, they don't have authority to issue regulations. And so when they do provide interpretations, these are a matter of policy, which means that different administrations may have different interpretations and policy positions. Some administrations are more aggressive in pursuing violations and issuing violations than others. And so just something to keep in mind as we work in the prevailing wage world. The department is required to post quarterly reports regarding the number of people employed on public works. This is an amendment that took effect earlier this year. The most recent report is available on the Department of Labor's main page. And they are also required to report on the participation of females and minorities on public works in Illinois. And the most recent report on this issue is also available by going to the department's Law and Rules tab, clicking on the Conciliation and Mediation tab, and then this report is available along the left-hand side of that webpage. Section 4 of the Act discusses that rates shall not be less than the rate that prevails for work of a similar character on a public works project in the locality where the work is performed under collective bargaining agreements, provided that at least 30% of laborers and mechanics in the same trade or occupation in the locality are employed under the CBA. Similar character is something that we'll discuss in a couple minutes. Again, the locality is based on the county where the work is being performed, and trade or occupations are listed on the Illinois Prevailing Wage schedules on the Department of Labor's website. The prevailing wage rate includes a base rate plus fringe benefit rates. And fringe benefits include health and welfare, retirement, vacation, and apprenticeship training benefits. Other benefits which are for the exclusive benefit of the employee. So some collective bargaining agreements, for example, have drug testing programs, but the cost of that program is not something that would be folded into a benefit under the Prevailing Wage Act because those aren't for the exclusive benefit of the employee. And then recently, the Department of Labor has added rates for some classifications, just a handful, that have additional overtime rates as part of the prevailing wage rate. And this is where a fringe benefit rate has a different rate when overtime comes into play. It may be time and a half or double time of the regular hourly rate. Public bodies have specific responsibilities under the Act, in particular, providing written notice to contractors stipulating that the prevailing wage applies. This stipulation should be included in bids and project specifications, as well as the contract. Or if a project is let without a contract, on some other written instrument, such as a purchase order. If the proper notice isn't provided, the public body can be responsible for interest, penalties, or fines. Contractors, however, always have the duty to comply with payment of the prevailing wage rate. This would not be a public body's responsibility. If there is an underpayment of the prevailing wage rate, that is the contractor's responsibility for back pay. There's also requirements in the Act that the public body include the requirement that contractors have prevailing wage guarantees in their bonds. Under the state prevailing wage law, if a prevailing wage rate is revised during the term of the contract, that revised rate applies. We typically see revisions when the prevailing wage rates are amended and posted in around July 15th of each year. Public bodies are responsible for notifying contractors when there's a revision, but public bodies can meet this duty to notify by putting in writing that prevailing wage rates are revised by the Department of Labor and available on the Department of Labor's website. So directing contractors to go to the Department of Labor's website to check prevailing wage schedules to determine if there have been any revisions. Contractors also are required to provide written stipulations that prevailing wage applies, and this applies in lower tier contracts as well. Contractors also need to post or provide other notice of the prevailing wage rate on the project or the business site, at a business site that's regularly visited by the workers. Illinois is unique in that it does include a private right of action under the Act. This is under federal Davis-Bacon laws. There is no private right of action, and this is not something that's very common in other states as well. This means that an employee can file a complaint with the Illinois Department of Labor, but they can also file a complaint in court. The scope of this private right of action was discussed in the Valerio v. Moore landscape case. In that case, the Chicago Park District had prevailing wage requirements in their contract that said the Prevailing Wage Act applies, quote, where applicable. And the circuit court concluded that that was an insufficient stipulation to give the workers a cause of action for damages under Section 11 of the Act. And ultimately, the Illinois Supreme Court agreed, and the case was dismissed. The Supreme Court's decision is very thorough, very detailed, very well reasoned in looking at the plain meaning of the statute, comparing language in Section 4 and Section 11. I think the court had the correct decision based on its analysis, but I don't think it was consistent with the intent of the law to provide broad worker protection on prevailing wage projects. And others agreed with that because the Prevailing Wage Act was amended in effective earlier this year. This amendment changed language in Section 11 that had referred to stipulated rates. It's a little difficult to see on this slide, but stipulated is struck through and replaced with the word prevailing. So a broader coverage that any worker paid less than the prevailing rates for work done shall have a right of action. And then the amendment also changes Section 4 to add right of action language that is consistent with Section 11. Section 4 of the Act also provides that anyone affected by a missing classification can request the Department of Labor investigate and establish a new classification, but that classification has to involve work that's substantially different from any existing classification as compared to the similar character language that we see in the Prevailing Wage Act. So this question of whether work is substantially different was addressed by the Department of Labor and the Landscape Contractors Association matter. This started with the Illinois Department of Labor and a decision that landscape work falls under existing classifications for laborer, operator, and truck driver. The Landscape Contractors Association was seeking to have a new classification specific to landscape laborers, landscape operators, and landscape truck drivers. The department concluded that there was not a substantial difference in the type of work performed, whether it was on a landscape project or a building project or a highway project. And so there was no new classification established, and the second district affirmed the department's decision. There have been a couple of classifications, new classifications added over the years. Most recently, a survey worker classification was added to the department's prevailing wage schedule. The description of a survey worker is that it's a worker operating survey equipment for the purpose of performing construction layout or grade checking. In 2015, a subclassification to the operator classification was added to cover ROV pilots, ROV tenders, diver wet tenders, and diver tenders. And in 2007, the material tester 1 and 2 classifications were added. Section 5 sets out certified payroll requirements. Contractors need to submit certified records no later than the 15th of the month following the month the work was performed. They need to keep records for 5 years from the last payment. And certified payrolls are considered public records in accordance with FOIA, with some information that can be redacted. The contractors file the records on the department's online database, and anyone can access these records by creating an Illinois Public ID account on the Department of Labor's website by going to that Laws and Rules tab in the Conciliation and Mediation section. Section 6 sets out public body and contractor liability for willfully failing to comply with or violating the act, and employees and agents can also be held liable. And then Section 9 discusses the surveys that the Department of Labor conducts during the month of June. I think I mentioned earlier that rates from that survey are posted on or by July 15th. Anyone that has an objection to the wage determination can file with the Department of Labor within 30 days after the rates are posted on the website. In Section 11, there's a notice that the state prevailing wage law may not be applicable on certain federal Davis-Bacon projects. In Illinois, we see this distinction sometimes on Illinois Department of Transportation projects. Some are covered under state prevailing wage law, some are covered with Davis-Bacon requirements. A contract may be void if prevailing wage requirements have not been met. And I mentioned earlier that there is a private right of action under Section 11 and also in Section 4. 11A discusses debarment under the Act, and 11B discusses whistleblower protections. An employee cannot be retaliated against or disciplined for filing a prevailing wage complaint or participating in an investigation. The Department of Labor has some very useful frequently asked questions on their website. There's a tab on the main page for FAQs, and then under the Conciliation and Mediation Division section, prevailing wage FAQs specific to different classification and topics, as well as an FAQ on certified payroll records. And I will wrap it up with that today. Jill mentioned we will we're happy to take some questions at the end of the presentation. And if we do run a little long, I'm happy to stick around to answer questions as well. Thank you.
Perfect. Thank you, Melissa. Okay, I am just gonna move on now to Frank. So thanks so much, Melissa, for that great presentation. I would like to introduce Frank Manzo IV. He's an economist at the Illinois Economic Policy Institute. Prior to working at ILEPI, he worked at the University of Illinois Labor Education Program and in the Federal Reserve System. He earned a Master's of Public Policy from the University of Chicago Harris School of Public Policy, a Bachelor's of Arts in Economics and Political Science from the University of Illinois at Urbana-Champaign, and an Advanced Certificate of Labor Studies from the University of Illinois Labor Education Program.
Well, thank you, Jill, and thank you to the IIIFFC for inviting me. And good morning to everyone else. I know you can't all see each other, but I wanted to thank the 150 or so of you who have taken time out of your day to join this webinar. Yeah, as Jill Melissa mentioned, we're taking Q&A with the button on the bottom of your screen. A couple of questions have come in, and we're going to answer those at the end here. So just wanted to make sure that was clear. And Jill also mentioned this, but these PowerPoints are going to be made available to you. So we are recording this as well. Anyways, as Jill mentioned, my name is Frank Manzo IV. I am an economist at the Illinois Economic Policy Institute, a nonprofit research organization that promotes thoughtful economic growth for businesses and working families. And we specialize in the construction industry. Over more than a decade, I personally have authored or co-authored about 50 reports on prevailing wage law specifically, and some others that pertain to them as well. And we do that with our academic colleagues from across the country, everywhere from University of Illinois to Michigan State University to the University of Utah and others. Now, I want you to all know the big takeaways from my presentation right away. So here they are, the 5 things that I hope you take away from my presentation. Number 1, prevailing wage standards level the playing field for contractors and strengthen the economy. Number 2, prevailing wage standards boost worker productivity and improve worksite safety. Number 3, these standards promote ladders into the middle class. Number 4, prevailing wage standards are the best value for taxpayers. And finally, prevailing wage standards help build quality infrastructure and strong communities in Illinois. So let's get into it. Now, Melissa kind of basically mentioned all of this, but this is a brief note on what these laws even are in the first place. Prevailing wages are local minimum wages for different types of skilled construction work on taxpayer-funded and ratepayer-funded projects that are based on what workers actually earn in a community. Their primary purpose is to create a level playing field by ensuring that our taxpayer dollars reflect local standards of compensation and craftsmanship. So that's what they are, and now here's what they do. Prevailing wage laws take labor costs out of the equation for contractors who are bidding on infrastructure projects. So instead of competing over the lowest possible pay that someone can get away with, prevailing wage says, here are the wages and benefits that are prevailing in your area. We're going to pay them, and we're going to incentivize competition based on all the other factors that go into a bid or otherwise put into a construction project. So things like quality, productivity, technological advances, management practices, materials and fuels usage, and profit margins. But that's it. Now, by taking labor costs out of the equation, prevailing wage standards level the playing field for contractors and strengthen the economy. Prevailing wage laws have been found to increase hiring of local contractors and local workers. The federal prevailing wage law, which Melissa mentioned, the Davis-Bacon Act, that actually reduces the share of projects going to out-of-state contractors by about 8%, according to the research. And then another example of a state law would be Oregon's prevailing wage law, where research found that it increased the share that went to in-state contractors by 12%. So similar results have been found across the entire country, whether you're looking at the federal, state, or even local prevailing wage laws. And the point is this: prevailing wage keeps more tax dollars, more income, more spending in the local community where an infrastructure project is being built. Now, the second thing that prevailing wage does is it boosts productivity and safety. Prevailing wage laws enable contractors to pay wages and benefits that attract and retain experienced workers, which is key, especially during times of skilled labor shortages, attracting and retaining experienced workers. But they also develop skilled workers by including apprenticeship contributions in with labor costs. Melissa had a slide about everything that's included in prevailing wage. Training is an important inclusion in Illinois' Prevailing Wage Act. And that's helps ensure that the next generation of workers is trained. Economic research does show that states that have these laws are successful at increasing apprenticeship training, with enrollments that are 8% higher in states with prevailing wage laws versus those that do not have these laws. And because the workers are better trained, they also tend to be safer. On-the-job injuries and fatalities are consistently found in study after study to be lower in states that have prevailing wage. And here's the deal, right? Construction is not low-skilled work. On the screen is the number of hours required to complete the operating engineer's Local 150 Joint Labor Management Apprenticeship Program. And so we have the 4 programs on the left. And in those programs, a trainee must go through between 6,400 and 9,000 hours of on-the-job and classroom training. And you can compare that to the right bar, which is the minimum requirement to earn a bachelor's degree from the University of Illinois, which is where I went for my undergraduate work. And I needed just about 5,800 hours of classroom training. Okay, registered apprenticeship programs typically require more hours than a 4-year college degree. And now, just as an aside, a few years back, I was speaking to an elected official who really wanted to question about how really highly skilled construction can be. And this particular individual had a graduate degree, like I do. And so I just asked him, how do you build a bridge? And he looked at me and said, what are you talking about? I said, do you know how to build a bridge? And he said, no, I have no idea how to build a bridge. And that, my friends, is exactly the point, right? The people who graduate from these programs build complex infrastructure projects that people like I and this elected official have no idea how to build. And by the way, here on the bottom of the screen, now getting away from that aside, is that the number of active construction apprentices has grown substantially. The number is 79% over the last decade, while undergraduate enrollment in our public system has kind of flatlined, decreased in some universities, and increased, I think it's 14% in the University of Illinois system. So much higher growth in registered apprenticeship programs in Illinois. In Illinois, the joint labor management apprenticeship programs are the gold standards, those like what you just saw on the last slide. These are union-affiliated programs that train 97% of all construction apprentices in Illinois on a year-to-year basis. Sometimes this is as much as 99%. But these programs, when you look on the left infographic on your screen, they have both higher completion rates and more diversity than the employer-only non-union programs. But I think the better comparison is what's on the right, and that is that they deliver training hours, graduation rates, and competitive earnings that rival the performance of our public 4-year universities. So put simply, registered apprenticeships are the bachelor's degrees of the construction industry. Full stop. Prevailing wage standards bolster this important system of workforce development. Prevailing wage promotes ladders into the middle class for all workers. Because those blue-collar construction workers are better trained and more productive in states with prevailing wage, they are better paid. That's largely true in industries across the country. If you're more productive, better paid, you're safer, or more productive, better trained, and safer, typically you're going to be better paid, better compensated for your labor. Now, since 2000, there have been a total of 23 studies on the impact of prevailing wage on construction worker earnings. And I've done the averages of all of them, and they range. They're always positive, but they typically turn out to be about 8% increase in construction worker earnings. And what's important, not on your screen, but what's really important is that this is true regardless of your background. Okay, because as long as they can do the work, all workers with the same skill proficiency performing the same job duties with the same equipment are paid the same prevailing wage and benefits package. No matter their racial background or gender identity or their religious preference or anything else you can think of. But here's the kicker. Because they earn higher incomes, blue-collar construction workers in these states contribute more in income, sales, and property taxes, and they're less likely to rely on government assistance programs. So what's on your screen is the results of a couple different national studies as examples, really. But prevailing wage has been found to boost construction worker health insurance coverage and retirement coverage. It also reduces construction worker poverty and food stamp reliance. And these construction workers are more likely to own their homes. And because they earn more, the homes they do own tend to have higher home values than those in states without prevailing wage. And that results in greater property tax contributions on average. Now, increasing tax revenues and reducing government expenditures on social safety net programs is one way that prevailing wage delivers value to taxpayers. Here's the other. By using skilled local workers who complete jobs right, on time, and on budget, prevailing wage stabilizes construction costs. And in fact, about 9 out of every 10 peer-reviewed academic studies that have been conducted on this topic since the turn of the millennium have concluded that prevailing wage laws have no impact on traditional public works construction costs. So the bulk of the research focuses on things like roads, bridges, schools, public buildings, parks. And there's, quite frankly, there's an economic consensus on this, and that is that prevailing wage standards have no effect on total costs. Now, how can that be when I just told you that it tends to boost worker earnings by, 8% or some amount, right? That is because labor costs are a low share of total costs in the entire construction industry. And it's approximately 23% of total costs. So there are people who think that if you remove or repeal prevailing wage standards, you can kind of somehow save, 10, sometimes 20, 25% on the cost of projects. And those people, unfortunately, are either really bad at math or they expect people to work for free because mathematically you can't. And I guess the point really here is that since labor costs only account for a small portion of overall costs, basically minor changes are needed to offset any impact of prevailing wages on labor costs. The biggest one is that they tend to be more productive. And so small changes in productivity can entirely offset the impact. Now, here's the point in my presentation where I do get to say that you don't have to take my word for it based on all the data and the years of crunching the numbers. But we have Ed Soliday, who was then the assistant Republican leader in the Indiana House of Representatives, who admitted that, quote, "We got rid of prevailing wage, and so far it hasn't saved us a penny," end quote. So no savings, but the other infographic, lower wages for workers. Blue-collar construction worker earnings fell after Indiana repealed its law. Wisconsin, same story, a state that did repeal its prevailing wage law last decade, and that has not only lowered wages for skilled construction workers and failed to deliver any cost savings on road construction projects, but it actually resulted in 60% more road construction projects going to out-of-state contractors. Okay, and just to rephrase this, these are projects that are funded by the people of Wisconsin, taxpayers in Wisconsin. And what repeal did was essentially create a jobs program for out-of-state businesses, mainly from places like Iowa and Florida. So not great for those taxpayers and economic development in Wisconsin. Now, I will say, and for those who may not be familiar, there were other states between 2015 and 2018 that did choose to repeal their state level prevailing wage laws. And so in addition to the two I just mentioned, we have West Virginia, Kentucky, Michigan, and Arkansas doing that. Two University of Illinois professors and I authored the only study that I'm aware of to look at all of these repeals that happened last decade. And again, the idea of these repeals, they were kind of sold as, on promises that by cutting middle-class wages and benefits of construction workers, it would somehow save taxpayers money on public projects. That's how they're sold. These did turn out to be empty promises. And worse, the data showed that repeal lowered construction worker earnings and led to greater reliance on government assistance programs yet again. Repeal also hurt local construction companies, public bodies, and taxpayers. On-the-job fatality rates increased. The number was 14%. Worker productivity growth slowed. And in-state contractors lost some of their market share to out-of-state firms, which means that fewer taxpayer dollars are being spent in their local economy. The point here is that getting rid of prevailing wage ended up being a self-inflicted wound on these states. Now, while I did just talk about those states that repealed their laws, really because they serve as cautionary tales for us in Illinois, I should mention that there has been a noticeable shift in state action the other way since 2019. And so we have many states like Illinois and Oregon and New York and others that have strengthened their laws, especially by expanding them to include new types of projects. As Melissa mentioned, solar and wind developments. Other states have expanded them to affordable housing projects. In addition to that, two states, Colorado and Virginia, enacted prevailing wage laws for the first time in a long time. And then Michigan decided that it had enough. It didn't save any money that was promised. Its construction wages were down. And so Michigan brought back prevailing wage this February. Okay, with all of this in mind, the Illinois Prevailing Wage Act, the results show that it tends to be good for workers, good for businesses, and good for families. In 2013, so more than a decade ago, a professor by the name of Robert Bruno from the University of Illinois and I authored a study on prevailing wage standards here in Illinois. And while we both have talked about how it is in dire need of an update because it's over a decade old, we did find that the Illinois Prevailing Wage Act increases employment in the state, boosts worker earnings and business output by $1 billion annually then, and increases state and local tax revenues by, again, at the time, about $44 million a year, all while reducing reliance on government assistance programs. And the point of this slide is to say, look, I'm not obviously taking, full credit here, but a whole new generation of researchers has not only understood kind of all these moving pieces that I've explained on the previous slides that go on here with prevailing wage, but also how to explain this policy to working professionals like yourselves, to the media, and probably even more importantly to lawmakers. And so on the screen, you see a kind of a recent example from last year of two professors from Cornell University. I've never met these two individuals before in my life, but I may like what they do because they wrote and released a study on prevailing wage in New York last September. And in that study, my work was cited 30 times, including a figure that was called the Manzo model of how prevailing wage laws affect project bids. And it looks pretty much exactly like the fourth slide that you saw from me today. We at ILEPI are pleased to see folks building upon and advancing this research because we can't do it alone. All right, I'm going to leave you with this. The public thinks that it's only fair that skilled construction workers who operate dangerous machinery and build roads, bridges, and schools that those workers are paid a competitive wage. A national poll found a clearly bipartisan majority of voters supporting prevailing wage laws. And every so often, a legislative challenge to federal Davis-Bacon Act prevailing wages is brought up. There are some folks in different policy circles talking about that now. But the last time it really truly came up was 2017 in Congress, and a bipartisan Congress voted overwhelmingly in favor of keeping prevailing wages. So that's why I say that prevailing wage standards are not a right or left issue, but a right or wrong issue. And that's really my final takeaway. The research is clear and consistent. A strong America is built locally with highly trained workers, and prevailing wage standards strengthen the economy, boost productivity and improve safety, and promote ladders into the middle class. By stabilizing construction costs and keeping construction workers off government assistance, they deliver value for taxpayers. And as a result, prevailing wage standards build quality infrastructure and strong communities right here in Illinois. So with that, I want to give you a quick chance to screenshot this or take a picture if you'd like. That's my contact information, but I know it's going to be sent out to everybody. So I want to thank you all for your time. And I think we have 5 to 10 minutes for a Q&A. But like Melissa, I'm happy to stay on if we go a little long. Thanks, everybody.
Thanks, Frank. We do have perfect. My video. There we go. Okay, yeah, so we do have a few questions that we will get to now. I answered one just in the chat about rates by county. And yes, you can go to labor.illinois.gov to find the current prevailing wage rates by county. But let's start with a question for, I think, Melissa. Under Section 6, if a contractor does not submit records for certified payroll, is it a violation, monetary or otherwise?
So Section 6 is the language that has responsibility for public bodies for willful violation. So a public body wouldn't be responsible for a contractor's failure to submit records. Section 5 does talk about contractors shall submit certified payroll records. And I think there is a possible violation there. I mentioned earlier, different administrations are more aggressive and sometimes what they issue violations on. I have seen a notice of violation, which is kind of like a preliminary step to a final violation issued by the department in the past, not too recently, but the Department of Labor had issued notices of violations to contractors for failure to submit certified payroll records. And often just that notice then triggers the contractor to go ahead and submit that record. And that's what the Department of Labor is looking for, right? The actual record. I haven't seen it lead to monetary violations, although it could, depending on, whether or not the contractor replies with a request from the department for the records.
Thank you. Another question to clarify, prevailing wage rates include the value of benefits.
Yes. So you had mentioned the prevailing wage schedules and where those are posted. When you look at the prevailing wage schedules, it's a spreadsheet that lists hourly rates. And then each of those benefits that I mentioned, it's called an annualized rate of the benefit. And so there's an hourly rate calculation for each of the benefits, the health and welfare, retirement, vacation, and training amounts that are part of the prevailing wage schedules.
Here's a question that I'm not sure, maybe Frank could maybe answer too, but also Melissa. What are the registered apprenticeship guidelines, and what's to stop any company from just slapping together a makeshift program and calling themselves an apprenticeship? I know ILEPI's kind of researched some of that, and I know obviously IIIFFC has too.
Yeah, Melissa, you can jump in if I don't directly answer, but I know they must be registered with U.S. Department of Labor. U.S. Department of Labor approved registered apprenticeship programs. So that's one. You can't just completely make anything up. It can be a problem in some instances, but broadly speaking, it's the the programs that prevail in a locality. So it might be a joint labor management program and the training contributions that go into those programs. There are some instances, and federal Davis-Bacon is probably even a little bit more applicable in this case, where if for whatever reason maybe a contractor does come in from out of state and doesn't want to pay the training, they still have to pay the total package. So they can give the workers a higher wage instead of paying the training. That usually applies a little bit more to the Davis-Bacon, and quite honestly, it's a little bit more of an issue in other states than it is here in Illinois. But it has to deal with the whole package too. Melissa, I'll let you answer maybe some more legally if you have anything to add.
No, the only thing I would mention is that that it is in Section 2 of the Act, in the definition of prevailing wage rate, that sets out that it does need to be a U.S. or a program approved by the United States Department of Labor. So that's where the standard comes in.
Yeah. Perfect. We have another question about, is the report on worker demographics on prevailing wage projects different from the minority and female apprenticeship program report? He hasn't been able to find that.
Yes, they are two different reports. The worker demographics is relatively new. I believe it's just this past session. And I think I did see that report for the first or second quarter on the Department of Labor's website. So at labor.illinois.gov, if you scroll down a little bit, I believe that report is there. Different from the Minority and Female Apprenticeship Program report, which has been in place since about 2019, or that's when that was enacted. And that's on a different page with the 2013 report, 2023 report being published.
Is all manual work, even under $2,000, does that need to be prevailing wages? For example, an electrician work under $2,000 or $2,000, does this need to be prevailing wage?
Yes. So the $2,000 number is something that comes in on federal Davis-Bacon projects. Federal Davis-Bacon has a $2,000 threshold. In Illinois, for state prevailing wage purposes, there is no threshold. So if it is a public body contracting with a contractor to perform the work, then it would be prevailing wage. If a public body's employees are performing the work, then the Prevailing Wage Act does not apply.
Do you know who reviews prevailing wage rates increases for full-time state employees and why it takes long for those employees to receive correct pay?
So this goes back to a comment I just made. If it is truly someone that's employed by the state, so someone who is an IDOT employee, for example, someone that's employed by the Capital Development Board, they would not be covered under the Prevailing Wage Act. It's just when the state contracts with a contractor for the work. And so I don't have an answer to increases in terms of rates for state employees. Sorry.
I think we have maybe another 5 questions, so we'll get those done right now. If the governmental body who bids out the work is the governmental body who bids out the work required to obtain all certified payroll? And if so, how long must they keep those records?
So now that we have the Department of Labor has set up their electronic database. The requirement is that contractors submit certified payroll records to the Department of Labor and its database. And so public bodies are no longer required to receive certified payroll records. It's great if they do in terms of being able to do their own kind of review and enforcement, but that's no longer required. There was kind of a transition period while the department was developing its database, but now the database is up and running. And so I don't think there is any requirement for the public body to take those records anymore.
Perfect. Does the Prevailing Wage Act apply when private developers enter in a redevelopment agreement that may contain forgivable loans?
Yeah, I'm sorry, I don't have an answer to that right off the top of my head. The coverage is very broad, but when it comes to redevelopment, I kind of like to look at the contract and look a little bit more at what's covered. And I don't know if anybody else has a comment on that or has experience please share it in the chat or
Yep.
yeah, thank you.
Same kind of with Cook County Class 6, 7, and 8 tax incentives. Is it possible to get those tax breaks pulled if they don't follow classifications?
Um, if they don't follow the classifications, so typically if someone is misclassifying a worker, I guess I'm not positive if the classification refers to the tax incentives or the classification of worker. Ultimately, it would be up to the county to kind of take that step if they think there's a prevailing wage violation to stop the payment. In terms of Department of Labor enforcement, the department's looking at whether or not workers are paid the correct rate. So that's probably not a 100% answer to the question, but hopefully it gives a little bit of insight.
Do you have, Melissa, do you have like a list of what penalties a contractor would maybe get if they don't file certified payroll? Do you know that?
There's nothing in the act specific. Penalties are sometimes based on a percentage of underpayment. But again, when it comes to filing certified payroll records, I don't have a specific answer.
Yep. Okay, we keep getting a few more, so a few more, bear with us. We're going a little bit over, but these are great questions, so thank you all for asking.
Oh, I think, Frank, do you have something to add or?
No, I was gonna say keep going. I appreciate all the questions. They mainly apply to you, Melissa, and kind of from the legal side. So apologies, I haven't been able to jump in more.
How can a governmental body monitor whether their contractors are being paid prevailing wage and verify the records that are submitted and match what is actually being paid?
That's a great question. I think public bodies do have a right to request certified payroll records. Certainly, you can go out onto the job site and ask employees about the wages that they're getting paid. That kind of on-site verification, it would be a great way to see if there is an issue.
Are workers getting wages earned after the IDOL performs an investigation, even though a notice of violation is not issued?
So my understanding of that question, if maybe someone's filed a complaint, whether it's a worker or third party, if there's an underpayment, my understanding is that the department is looking to settle cases, right? And so I don't know the exact steps in terms of do they notify the contractor without a notice. I believe the initial step is to reach out to a contractor to determine whether or not there's a potential underpayment. And if they find that underpayment, try to resolve it informally with the contractor before issuing a notice of violation. Again, the priority being, making sure workers are paid the prevailing wage rate.
Here's a question that maybe Frank can answer, and also Melissa, because I know you've looked at the associated building and contractors. What are your thoughts regarding ABC, an agency that provides apprenticeship and training programs for generally non-union firms?
Yeah, I can go first. I'll say in 2020, our organization with the University of Illinois released a report on registered apprenticeship programs in Illinois, completion rates, enrollment, diversity, met numbers, things like that, and found that the joint labor management programs were very much on par with public universities, including on almost every metric, earnings on par with public universities. Completion rates in those programs are 50-60%. That was one of the slides I kind of showed you. We did look at the ABC program as part of that. It's one of the registered apprenticeship programs in our state, and they tend to graduate only about 1/6 of their apprentices. It's 16% in the report, so have a much lower graduation rate. Do tend to offer lower exit or journey worker wages. Might still be kind of middle class, but it tends to be lower middle class, something closer to a high school degree to an associate's degree, whereas the other side is closer to is a bachelor's degree or more. And then the other thing, the ABC is a organization in the state that represents contractors, but when you look at it, they represent basically 1/3 or 1% of total contractors in the state, then graduate again 1% of all apprentices in the state. So they're pretty small. In fact, Melissa and Jill's organization, the IIIFFC, I believe represents 3 times as many contractors, businesses in the construction industry, and their apprentices are at least 3 times more. So IIIFFC tends to be a better resource on these matters.
Well, I don't have anything to add to Frank's answer. Thank you.
Then I think we just have kind of 2 kind of remaining questions related to TIF districts. So are projects within TIF districts who receive federal grant money covered by prevailing wage?
That's an interesting question, multi-layered. So that for Illinois state prevailing wage purposes, where I mentioned earlier, TIF incentives are not covered by the prevailing wage requirement. If there's also federal funding involved, that's an it depends answer, and the question of whether or not the grants and the source of the grants has federal Davis-Bacon requirements there. If the grant funding has Davis-Bacon requirements, then federal prevailing wage would apply. But not all federal grants have Davis-Bacon requirements, so it does depend.
Yep. Just kind of, I think maybe 1 or 2 more. I'm assuming this one says, can you tell me what types of, I think it's contracts wouldn't be prevailing wage as opposed to contacts? That was in the chat.
Honestly, only off the top of my head, it's the TIF is the main exception that we typically see. The language of the act is very broad. I mentioned at the beginning in terms of paid for wholly or in part out of public funds, paid in part with bonds, grants, loans, or other funds made available by or through the state or any political subdivision. So it is very broad, but that's not to say that we, haven't seen those exceptions. And so we look at those cases, as they come with all the contract and the facts involved.
Yep. And then just one more question, and I'm not sure if this is in relation to what kind of Frank was talking about with apprenticeship programs, but must they be a part of an approved apprenticeship program or just pay the rate? Because I think what Frank was kind of talking about, or maybe mostly you were the one that was talking about not being in a registered apprenticeship program or something. They could just pay the rate if they're out of state or something.
Go ahead, Bill. All right, go ahead.
Well, no, so correct. You do not have to be in a program. Frank mentioned earlier, it's the ensuring that the total prevailing wage rate is paid. So if a contractor doesn't participate in a USDOL approved apprenticeship program that they are making contributions to, then that prevailing wage rate, say $1 per hour, would be paid to the employee on their check because it's not going into an approved apprenticeship fund.
And just to add to that, so that's exactly right. However, one of the economic benefits, or one of the primary purposes of prevailing wage, it delivers value in that it does increase the amount of funding that goes to private registered apprenticeship programs in communities across Illinois. So while they can do that, it's potentially preferable for it to go towards investing in the next generation of skilled workers so that we don't have a massive labor shortage. We're already experiencing that in Illinois and across the country in a lot of areas, and skilled construction is one of those. But states with prevailing wage laws tend to have more apprentices and not face as dire of a situation as those without.
Great. Well, I think we answered all their questions, so we didn't go over too much. Thank you all for asking those great questions. If you have more questions, I will send out our contact information, so please reach out. We're happy to, get back to you with any, answers we have. And I just wanted to thank you all again for joining us today. It was very informative and very, great. So thank you again to Frank and Melissa for presenting on prevailing wage. And yes, thank you. Thank you all. Have a great rest of your day.
Thank
Thank
you.
you.